Morning, Rachel.
Morning, Marcia.
So, the long-awaited Corporate Insolvency and Governance Bill is here. It had its first reading in the Commons on the 20th of May. It's around 250 pages, and I don't know whether you've noticed it, but certainly LinkedIn is absolutely buckling under the weight of bulletins. So here it is, another feeding frenzy for lawyers and IPs alike. Can we cover it in less than 10 minutes with no pictures, no subtitles, no hesitation and no repetition?
Ooh, challenge accepted. Let's go. So the bill is not law yet. It will be expedited through Parliament and likely ETA onto statute books is the end of June, early July. The bill introduces a number of permanent and temporary changes to the existing regime, but overall it's pretty debtor friendly and overwhelmingly pro-rescue culture.
Okay, well, I'll take the permanent reforms, kicking off with the new temporary moratorium procedure. Directors can apply to court for a temporary moratorium where their company is facing financial difficulty. By temporary, the initial period at least is 20 days, although it can be extended with creditor consent and ultimately by the court, and it can last up to a year, like the administration regime. Essentially, it's a protection on winding up petitions being presented and a temporary payment holiday on debts. Creditors can't bring enforcement or legal proceedings during the moratorium period, and essentially, much like administration, the objective is to give the directors breathing space while they attempt to raise capital or restructure. Unlike administrations, the objective of the moratorium has to be survival, so there's no default objective. Like the administration procedure, the moratorium involves the appointment of an IP to monitor the process, while the directors essentially go ahead with their ordinary trading activities. So there are obvious parallels there at play with what's come to be known as the light touch administration. The moratorium comes to an end when it's served its course, or if it's all gone horribly wrong, at the point at which the company enters into an insolvency procedure. The second important permanent change is with regard to the operation of termination on insolvency provisions in supply contracts. Now, those are suspended on an insolvency, which is a big change. As we all know, supply contracts almost always contain a clause which allows a supplier to stop supplying a company once it's entered into an insolvency process or restructuring procedure. And under amendments to the Insolvency Act, these clauses are simply going to cease to have effect. And once the company's gone into that procedure, the supplier won't be able to make a condition of future supply the payment up front of monies already owed.
Yeah, I mean, I think that's a really surprising permanent change, and because it would mean presumably that the debtor company could sue for breach of contract for failure to supply despite owing massive arrears. It seems it's incredibly debtor friendly, as we say.
Yes, absolutely. But there is a saving. If the court is satisfied that the continuation of the contract is going to cause hardship for the supplier, it can effectively disapply those provisions. And there's also exceptions for small businesses, and small being defined by reference to the usual criteria, number of employees, profit and loss account turnover, and the like. The final important permanent change that I'm going to address is a new, if you like, scheme of arrangement for companies in financial difficulties. It's very like the Companies Act schemes that we all know and love and are familiar with. Essentially, there's going to be a new Part 26A to the Companies Act. The added bonus, or the USP, is what the online commentators are calling the cross-class cramdown. So many C's. Dissenting creditors or members can be bound into a restructuring plan voted on by the majority, whether or not that majority is in the same class. And as with the schemes that we're familiar with, the court retains an overall discretion whether or not to sanction the arrangement. So that's me done. Over to you. Me back to my coffee. You tell us about the temporary measures.
So there are similarly 3 temporary measures which cover new problems we're experiencing caused by COVID-19. And again, these are on the whole mostly debtor-friendly measures. The first is a restriction on statutory demands and winding up petitions. So no petition can be presented against a registered or unregistered company where the demand was served during the relevant period, that being 1st of March 2020 to 30th of June 2020, or 1 month after the bill becomes law, whichever's later. So a creditor may also not, during the relevant period, present a petition for the winding up of a company unless the creditor has reasonable grounds for believing that coronavirus has not had a financial effect on the company, or that the facts giving rise to the ground would have arisen in any event without the effect of coronavirus. Now, for myself, I think it's hard to imagine a company right now where coronavirus has not had at least some financial impact. It seems like a fairly low threshold test, a financial effect.
Yeah, absolutely. And how does the creditor prove a negative? I suppose the takeaway here is when you're advising a creditor client that they have to exercise extreme caution when deciding to proceed to enforce their claim by way of winding up proceedings.
Yeah. And the bill also provides that certain winding up orders that have been made after the 27th of April 2020, but before the bill came into force, are to be regarded as void. So if the winding up order would not have been made had these new provisions been in force at the time, it will be void, i.e. you could show that coronavirus has had some effect on the business.
So that's massive. If your client was on the wrong end of a winding up petition over that period, I suppose you as the lawyer will now have to contact the directors or the members, as the case may be, saying, right, we need to review all of these winding up orders.
Yeah, definitely. Yeah. And the second temporary measure is the suspension of liability for wrongful trading. So the bill provides that the court is to assume that the person, usually the director, is not responsible for any worsening of the financial position of the company or its creditors that occurs during the period, again, 1st of March to 30th of June. Now, there's no doubt here that the intention was to ease directors' concerns about attempting to trade through the current pandemic, despite the very real risk that they may, in any event, end up in insolvent liquidation. But I think it's really important to bear in mind that that temporary measure doesn't affect directors' general duties, which continue to apply, and in particular, the duty to take into account creditors' interests when the company is in the vicinity of insolvency. To me, I think that's a really tricky balancing act for directors, and I think it's important that they take appropriate insolvency advice where necessary, because that's going to be tough.
And be told that it's not a get out of jail free card.
Yeah, exactly. And finally, there are some small but important changes permitting electronic meetings and extending filing periods. So this makes allowance for the fact that people are obviously struggling in the current climate to meet in person, and that's having a delay on running the business and general admin, so preparing and filing accounts.
Good to know. Boring but important.
Boring but important.
Anyway, we've done it. Within our 10 minutes.
Cheers.
Happy days.